We're ready in this matter. Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Israel Crane. Mr. Crane, state your name for the record.
Israel Crane.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is all complete.
Yes. The best of our knowledge, Your Honor.
All right. People would have their witnesses available the 25th. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
I do just have one thing I would like to address with the court.
Yes.
So Mr. Crane was in Michigan because he requested to be supervised while being out for his conviction for armed robbery and FA out of Virginia. Agent Bennett, who I believe is supervising his release here in Michigan, notified our office this morning that he believes that the defendant is having contact with the victim through his mother.
Buckle up, guys. Today we're stepping into a courtroom where procedure quietly sets a trap for what's coming next. The music fades. The case is called. Names are placed on a record, and what sounds routine is anything but. This opening establishes authority, expectations, and the calm before the storm. The court isn't emotional yet, but the structure, timing, and formal tone signal that decisions made today will carry real weight for the people standing before the bench.
I do want to note that I was not able to find any jail calls to the victim directly from Mr. Crane, but I am concerned based off of the need that Agent Bennett felt the need to notify us of this. I have not had an opportunity to have a discussion with Agent Bennett with regard to this allegation or what the basis for it is, but I am concerned. I have not had an agent feel the need to contact our office to notify me of indirect contact on an
Okay, but are there then phone calls that would even remotely substantiate that, like phone calls to his mother?
Yes.
But the content of those particular phone calls, we don't know.
I have not had an opportunity to listen to them yet.
Mr. Brown, I'm not sure what they're asking.
I think they're asking for his phone privileges to be revoked, but
They haven't said that he's had any contact. They haven't shown that he's directed anyone to do anything. We don't even know the extent of his mother's relationship with the complaining witness in this case. Without those facts, they're not asking for anything. They're just putting that out there.
Here's what I'll do. Is somebody going to be able to listen to those calls to indicate? I mean, it's one thing if he's contacting his mother and his mother is then reaching out in some way, whatever, as opposed to him attempting to try to send messages through his mother. There's going to be a difference. So I'm reluctant to do anything until such time as there's some indication that that's what's happening in terms of a third-party contact. So maybe if...
All right, guys, this is where tension starts creeping in. The prosecutor raises a red flag about possible indirect contact with victim. Not directly, but through family. Nothing is proven yet, but the concern alone shifts the mood. As an outside observer, you can feel how a simple allegation, without evidence, can still put defendant's freedom at risk. This moment shows how fragile bond conditions are once trust starts to crack.
You get a statement from the officer as to how they know that, what information has come to them, get that to Mr. Brown and to the court. I may change that decision so that you're aware, Mr. Brown, where if I look at it and it appears to me that that's the case, then I may revoke his privileges, and you can certainly have a hearing before Judge Washington or this court regarding that. Okay. So I think that's probably the best way at this juncture to handle it. Calls the case, People versus Deshaun McFarland.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. McFarland. Sir, what's your name for the court?
McFarland.
In this case, Your Honor, we're asking the court to please set for exam. Discovery should be complete.
That is correct, Your Honor. Discovery.
People would have their witnesses available the 25th. Preliminary examination, June 25th, 2024, 9 a.m. before judge.
Here's where the judge slows everything down and demands clarity. Instead of reacting emotionally, the court draws a sharp line between innocent family communication and intentional obstruction. From a third-party view, this is restraint in action. The judge refuses to speculate, insists on proof, and reminds everyone that not every allegation deserves punishment. It's a brief pause, but it raises suspense because the decision is clearly not final yet.
Washington.
Your Honor, there is one matter.
Of course you would. Go ahead.
Your Honor, I do want to note that there have been no calls directly to the victim. However, I do have notes that, and I did notify Mr. Bernstein of this, as well as request to have the jail clothes released to him, that the defendant has been talking to his grandmother and informing and instructing her to contact the victim about dropping the PPO. I am extremely concerned. This is not an isolated phone call, but it seems to be repetitive and continuous and come up in multiple conversations. As a result, I also want to follow up and say that it does appear that the victim was contacted by the grandmother, according to later conversations, and that she said she would not be dropping the PPO. She wants to keep it in place for a year and see how he does. But at this point, it's not just a request for indirect contact, it is successful indirect contact. I would be requesting for his phone.
Well, it certainly hurts the bond argument that I was planning on making today, Your Honor. I don't have a response. Let me give that.
Well, I'll just say this. I'm a bit concerned that the contact was made. And that the contact that's made is of a nature that is obstructive. It wasn't just, hi, how you doing? That concerns me.
Now the dynamic shifts completely. The prosecution doesn't just allege indirect contact. They claim it actually worked. The grandmother allegedly reached the victim, and the victim responded. From the outside, this is the moment the floor drops out. What was once hypothetical becomes actionable, and you can almost hear the bond argument collapsing in real time as the court processes that the contact wasn't accidental or harmless.
So two things are going to happen here. Defendant's phone privileges are hereby ordered revoked. Defendant's bond is also increased to $200,000 cash surety.
You gotta stop. You can't say this.
Thank you. Call the case. People versus, is it Hazel Jacobs?
Assistant Public Defender on behalf of Hazel Jacobs, who approaches.
Take Jane.
Mr. Jacobs. Thank you. Your Honor.
Yes.
I'm so sorry. Just looking for my notes on this one. I do know that, Your Honor, if we can be heard on bond after this, I would be appreciative. And I understand that there is a...
This is a hammer drop. The judge determines the contact wasn't casual but obstructive, and the consequences are immediate. Phone privileges gone. Bond skyrockets to an amount that changes everything. Watching as an observer, this is a textbook example of how one misstep, especially involving a victim, can instantly turn pretrial freedom into a financial and legal nightmare.
An alleged violation that we need to go over. We would like to want to waiver of your exam. tried to get a hold of my client, Your Honor. I was not able to explain to him because we didn't know that he was in the jail until late yesterday. So I have not been able to talk to him. I would ask to adjourn this for 1 week so I can go over everything with him and explain exactly what the next options are. So if we could just get 1 week, that'd be. I wouldn't.
June 20th, 2000.
Not right now. You stop talking. Listen, I have the information.
June 24th, 2020. June 20th, 2024, 9 a.m. for probable cause.
Thank you, Your Honor.
This time you didn't want to address bond, did you? I have a conditional violation. If you want to address it, you can go ahead, but.
I understand, Your Honor. As it pertains to the conditional violation, my client would have me advise the court that.
The next case opens with uncertainty and unprepared defense counsel asking for time. From the outside, it's clear the court's patience is thin after what just happened. The judge interrupts, refocuses, and keeps control tight. This moment shows how quickly the courtroom shifts gears. New defendant, same seriousness, and how being unready can cost credibility before arguments even begin.
With regard to the report that the court is in receipt of, the argument involving the subject of the no contact order, which was heard by his neighbors, occurred while he was not home, occurred while the individual he has the no contact on was arguing with someone that she was talking to the phone on. He advises that she was at home without his knowledge and that he came home to find her there. It advises that the ensuing argument resulted after she started screaming and crying when he asked her to leave so he wouldn't violate his conditional bond, Your Honor. Additionally, he advises that he has orientation for a new job next week and he will be unable to gain an income used to support his father and child if he loses that new job, which will happen if he does not attend that orientation. So he would be asking for a release based on the information that the court's in receipt of.
A response from the people.
He was home. He told the police that he was home. He actually told the police that she's the person he was arguing with. He actually went on to tell the police that he's the person she was yelling at. I'm not sure why he doesn't remember talking to the police. I'm not sure why he doesn't know that the police were writing a report to that. That all of us have this report, including all of his admissions to being and having contact with her. So yes, this occurred at his apartment. However, he was there. The police spoke with her and spoke with him.
Here the defense tries to reframe a bond violation as a misunderstanding. They claim the protected person showed up unexpectedly and that the defendant tried to avoid trouble. As a third-party observer, you hear the appeal to sympathy, job prospects, family responsibilities, consequences beyond jail. It's a strategic moment, but it hinges entirely on whether the court believes intent or excuses.
And the police arrested him for having contact with her. And that's when he went on to admit to him then that he was in an argument with her, that she was screaming at him, and he acknowledged the no contact order with her. So that's the conditional violation. The other reason that Your Honor should continue the defendant's bond as it currently is ordered is because when my office charged this case, we requested $25,000 cash surety on this, and we're not given that as a arraignment. This is a case where the defendant is charged with strangulation and reported to the police. The defendant was punching her in the face, got on top of her, while she was laying on her back on the bed. The defendant was on top of her, pinning her arms on the bed and using his other hand to choke her. She told the police the defendant squeezed her throat with his hand and then started using the blade of his forearm, so it's the bone there, to apply pressure to her throat. She said she punched him in the face in an attempt to get him off of her, and that she felt that she was being choked for approximately 30 seconds while she struggled to breathe. The police noted in their report that the victim's throat was covered in scratch marks and light red bruising. She indicated she did not lose consciousness, but she had to fight him off on her bed. And then the defendant, while she was trying to fight him off of her, the defendant went on to fight her right shoulder.
the police officer wrote in the report, I observed what appeared to be an obvious bite mark on her shoulder, visible teeth marks and bruising. It goes on. The victim continues to report that he's been accidentally punching her in the head. The officer does a great job of, as she's reporting what occurred to her, keep that in his next statement. He's on to report what he observed. He says, I observed raised bruises or goose eggs on the side and back of her head. And it continues. So, Your Honor, we requested $25,000 just based on the facts of this case alone, as well as the danger this defendant presents to not only this victim but the community. But then he goes on to have contact with her in addition to the police that can come before Your Honor and try to tell us a different story. So I'm asking that Your Honor not reduce bond in any way this time. Thank you.
Your Honor, may I respond to that?
No.
Your Honor, as it pertains to the allegations of the alleged crime here, a determination was made by the magistrate as to his release. He was out. We don't deny, as it pertains to the allegations on the bond violation, that any of that happened, other than the fact that he arrived home from a haircut and she was there and he tried to get her to leave so that he wasn't in violation of that bond condition. He advises that he has a tether. He's willing to do home confinement. We just would ask for consideration and his release.
This is where sympathy runs into cold facts. The prosecutor lays out a graphic, detailed police report describing strangulation, injuries, and admissions. From an external perspective, this is an argument. It's damage control for the record. The contrast between the defense's story and documented injuries is stark, and you can feel the momentum swing decisively back toward the state.
No, he was brought in on a conditional bond violation. It was not arraigned before the magistrate on a conditional bond release.
I'm sorry. I didn't mean to cut you off. I'll stop talking.
Go ahead. What were you going to?
I was just with regard to the original charges, Your Honor, not the bond violation.
Right.
Okay.
Taking all that into account, what the story that just relayed to me doesn't match the police report at all. In regard to what the defendant is having counsel put forth to the court.
Okay.
Because of the conditional bond violation, taking that into account with the allegations, at least as it regards this particular case, the court's going to set the defendant's bond in the amount of $50,000 cash surety. And we'll see him next week.
Thank you, Your Honor.
Versus Omar Anderson.
Good morning, Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Anderson, who is approaching. Could you state your name for the record?
Omar Anderson. Thank you.
Your Honor, I was just informed last night that there are some jail calls that were delivered to my inbox after the beginning of this docket today. So I would like to ask for an adjournment so that we can listen to those and decide on how to proceed from there.
The judge makes it clear the stories don't line up. Calmly but firmly. The court states that what was just argued doesn't match the police report at all. Bond is set, and the ruling feels inevitable. As an observer, this moment reinforces a hard truth. Credibility matters, and once the court loses confidence, outcomes become far less forgiving.
Go ahead. What?
That is correct, Your Honor. He was arraigned on May 31st, and between May 31st and prior to his release on June 3rd, including on June 3rd, he made 8 calls to the victim. I do want to note that the underlying allegations here is that he had a valid and served PPO protecting the victim. At that time, he came out and threw a brick through the back windshield of her car, which damaged the front windshield of her car as well, and then fled the scene. Since the calls from the victim, to the victim from when he was in custody, she has since filed to terminate the PPO, and he has been out. I'm extremely concerned that
I just want to make sure I'm clear. There was a PPO.
Correct.
He is lodged at the jail at some point.
Correct.
From the jail, there are calls being made.
Correct. after his arraignment.
Go ahead.
I am extremely concerned at the potential for undue influence on the defendant's part over the victim in this case.
Another case, another warning sign. This time, the issue is repeated jail calls to a protected person while a protective order was active. From the outside, the pattern is alarming. The concern isn't just contact, it's influence. The court begins to question whether the system itself is being manipulated, and the tension builds around what those calls might reveal.